Okay. All right, sorry to keep you waiting. So, is it Ms. Jimenez or Ms. Garcia? Which one?
Jimenez Garcia.
Jimenez Garcia. All right, come on up here. So I'm Judge McBurney. Nice to meet you. Tell me a little bit about you. Where did you just graduate? You've been a lawyer in another state. What's your situation?
No, so I graduated from UGA Law in May 2024.
Right. Yeah.
That's right. And so I am a baby lawyer.
A baby lawyer.
Yeah, at Smith Russell.
Okay, I was gonna say where you do your baby lawyering.
Yep.
Campbell, what are you in a particular area?
For the most part, I'm doing white collar and government investigations.
Okay.
Like Tony Cochran and
Heard of him? Heard of him too?
Yeah.
I walked in, I figured I was in trouble because they were flanking on either side. Either you're in trouble or I'm in trouble.
No, I hope never to be on.
A lot of legal horsepower.
Yeah, and then I worked with Emily last summer.
Okay.
Emily Ward.
Great.
Yeah.
Okay. And who did you bring with you? I see other happy, smiling people.
This is my mom, Adriana.
Hi, Mom.
My dad, Caesar, my cousin, Brenda, and my boyfriend, David.
Hey, David.
Who was a juror in a case of yours.
Uh-oh. Yikes, how'd that go?
It was fine.
You were like, you actually made it onto the
Yeah, I
jury.
was sitting up there for weeks.
What was the case about?
It was a murder trial.
A murder trial. That's what we do. Okay. And did you find the person guilty or not guilty?
We did.
Okay. What was it about? Obviously, someone died.
It was like a jealous ex-boyfriend, those text messages.
Oh, Carlos Dill.
Yes.
We just had his motion for new trial hearing. Yeah, because you get lots of bites at the apple. And so the main argument that he now has a new lawyer for appeals, the main argument, you had a fellow juror who, when the woman who was sort of in, really wasn't a love triangle, because I think the other guy was platonic. But anyway, the woman who was the ex-girlfriend, when she was testifying, she cried a lot because her friend got shot in front of her, in front of us, and they watched it on video. And one of your colleagues tried to hug her during a break, said, I feel so bad. She said, I'm a very empathetic person, juror number 2. And so that was the main argument, was that I committed error because I didn't excuse her. I didn't see this happen. It happened out in the hallway. And the victim advocate said, you can't touch a witness. And the jurors like, I'm so sorry. And then the state brought it to attention. I think I had to tell all of you, like, hey, just in case you're on a break, don't hug any witnesses. But they're saying that was error. She had a bias and I should have excused her. So we have to work through that. So Carlos Dill, he patched in from Coffee Correctional, wherever, he's serving his life sentence. Thank you for your service. Those are not easy things, but this is about you, not about your boyfriend. But I'm glad he had a connection.
Yeah, I didn't know it until after I scheduled. I was like,
Small
we're
world.
going to- yeah.
What are
it's
the
like,
odds?
What does he look like?
Yeah. There are so many judges here. You guys are both looking out.
Yeah.
All right, so here's how this is gonna work. We'll sign the paperwork in a minute. I've got this nice little oath here. You don't get to see it while I read it. I'll read it, you'll repeat after me. It starts with I, we both say I. And I sit here until you say your name. I won't say your name, so we both say I. Once you get your name out, then we'll
Okay.
do the rest.
Okay.
You ready?
Yes.
How would you like us to stand? She's the interesting one. You want us to stand?
You both are interesting, so.
Okay, all right, we'll stand a little closer. Okay, well, why don't we do this so we're,
Yes.
there you go. All right, is that better?
Yeah.
All right. All right, right hand up.
I, Laura Jimenez Garcia,
Swear that I will truly and honestly,
swear that I will truly and honestly,
justly and uprightly
justly and uprightly
conduct myself as a member
conduct myself as a member
of this learned profession.
of this learned profession,
Pat themselves on the back there. And in accordance with
and in accordance with
the Georgia rules of professional conduct
the Georgia rules of professional conduct
as an attorney and counselor.
as an attorney and counselor,
And that I will support and defend
and that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of Georgia.
and the Constitution of the State of Georgia.
So help me God.
So help me God.
Congratulations.
Thank you.
Good work.
Thank you so much.
Let me sign this stuff. You have to sign one. Let me get a good sign. These cameras were here for you, by the way.
Yeah.
Live WSB TV tonight.
Here's
So
the
then it's
book all the
Garcia
press.
sworn in.
All in some favors.
Yep,
Thank
hot new
you.
lawyer, breaking all the trends. With the umbrella. All right, so, she gave you a special signing pen, sign there. All right, and then you don't sign this, but I do, and the clerk of court already signed it.
Good signature.
Hey, thanks, I do it a few times a day. So I still can't do it on a baseball though. My son plays baseball, he's trying to figure out how to do autographs, and it's hard, it's small and round.
He's at the autograph phase now.
He thinks he is, he's
Okay.
not, he just got into
No, he is.
college to play baseball,
No,
so
he
he's
is.
thinking that people want his autograph. So that's for you, you'll be taken care of, I think there may be a little more processing that has to happen. Do you have to go work today, or can you take like a celebratory, I got sworn in?
I'm going to work, but in
Okay,
a little bit.
celebratory lunch, what are we gonna do?
In a little, we might do a little something,
Little
but
something, good. Well, anytime you wanna come by and watch court, we do civil work also, it's not just murder trials. So anytime you wanna see what's happening in the court, feel free to reach out. And if it's not in here, I can find out who else is doing something civil, watch a motion for summary judgment or whatever else is going on. We're happy to show you the ropes here, because you'll probably be in here sometime soon.
Yeah.
All right,
thank you so much. I
congratulations.
really appreciate it.
Do you all wanna get a picture with your daughter and all that? Deputy Gordon is here, he is a great photographer.
Oh, okay.
Thanks.
So however you wanna do it, we can stand, that seal's not way back there, but however you want, I think this was your pen.
Do you remember swearing in Alex Smolian
So.
like a month ago?
Yes, I do.
She was the one who kind of taught me how to
Hooked us up.
get in here.
All right.
She and
Do
I
you
were
want
really good friends in
The
school.
green, do you want the green folder back?
Yes.
Maybe over here.
Right, yeah, why don't we can
This
do,
is the-
or like with that background,
Yeah,
either
I
do
think,
one
I
of the,
think about.
this is a better background than the gray wall.
Oh, this background?
No, right there.
Oh,
Yeah,
okay.
just I'll stand.
Just sit in the middle?
Yeah, right here in the middle. Yeah, guest of honor. All right. Oh, Gordon got fired. All right. It's all right. Good. How'd you guys get in position? Okay.
Right on 3, 1, 2, 3. Perfect. All right.
Okay, we're good. All right. Thank you so much. Yes, get the legal team in.
Yes.
Paying for this ceremony.
All right on 3, 1, 2, 3. Just snapping. That is perfect.
All right.
Thank you. Thank you so much.
You're very welcome.
Yes, thank you very much.
Likewise.
You're welcome.
Good luck. You're welcome.
We will.
Excellent.
We will, we are.
Good. Good. You're very welcome. Congratulations. Yeah, it's very exciting. Nah, it's good. She's accomplished something important.
Oh, really? I still enjoy what I do, and there's a lot to look forward to.
One day at a time.
That's right.
Yeah.
One signature to copy.
Yeah. Welcome. Wherever you want to sit. Yeah, go for it. It's empty right now. If you can get there before I do, it is yours.
We're covering for both today.
Oh, okay. Yeah, that one just snuck in. Somehow the clerk's office missed it.
Yeah, that's what, so I appreciate you fitting this on.
Well, it's one of 10. It's a great day. We'll get some done before lunch and some after.
You know, I told you the new procedure, which is how we got this, because we filed it in November.
It's not a new procedure, but what we're, well, it should be invisible to you all. The clerk's office isn't making calendars anymore. They're simply sending to the judge 2 weeks out. These are all the people who had a bond deferral. And the magistrates are supposed to use this new form. They're not actually ruling on bond deferred. And they sweep for that. And I think your guy didn't get a deferral. He got a bond order that said no bond.
I see.
And they're not actually saying bond or no bond.
Right, because they can't hear it.
Yeah, it's not our jurisdiction. So I think that's how it got missed.
Appreciate the input.
You bet. We're working the kinks out. So what's the word? See who's here? Okay, I'll just go away and then. Yeah, I let people, I don't know what they're doing about phones, but that's not.
There's Faraday bags out there.
There's what?
Faraday bags.
Okay, so they're taking phones?
Yeah, if you're not an attorney, put them in a bag.
Okay, so they let the attorneys keep them?
Yeah.
Good, okay. Good morning. So, yes, you can let people in and then bring up whoever's here, and we'll start with that. Good morning. Thanks for your message.
Oh, okay.
So we're gonna start with whoever they bring up.
Okay. And then, just.
Okay, yeah, because Mr. Clark was here,
Yes,
so that'll make Mr. Tevis happy, because he's here for that.
right.
See you shortly. Yeah.
That's why I sent you an email with that. I was
Yes.
like, I'm just gonna
Okay.
look at it. There's no, I mean, I don't know when
So we'll just, it'll be a little.
So there were 6.
Yeah, got that. It's the only one that I don't know all about.
Okay.
Not in the house, you told me that. That's one of them.
Yes, sir. Thank you.
Okay. I don't see any prosecutor here, it's gonna be a little tricky. All right. Right. Yeah.
We're almost in recognition.
Good.
I think it's, you know,
Where's Miss Clark?
Should be on the way. She may be joining via whatever. Zoom maybe.
Okay, she didn't say anything about that, that's fine.
No, he's not here.
That's good.
What's the name?
Good morning.
Morning, Ted, how are you?
I'm fine. We will be taking the cases as they get people up. It's a little chaotic downstairs. So I'm not quite sure what the flow will be.
I could run downstairs at 9:30, just Winter's first, very brief.
I was told there's something in 1C, there's something next door, there's something in here that is of interest to lots of folks. I'm a little more focused on all the murder cases, but so will you be handling all of the bond hearings? There's one add-on that is sex crime. Okay, I saw Ms. Clark kind of briefly in the courtroom and then she left.
Sure, there's a couple who have, I think there's 3 defendants who have murder counts, but also the cat cases, so she'll be handling those as well.
Okay, got it. Yeah, there's a couple whose kid OD. She'll do that. Okay, and then the add-on with, I think that's Mr. Tevis is handling that. Okay. Is she coming back here? All right. And on the defense side, sir, do you have the good fortune of handling all of the appointed cases?
Your Honor, as far as I know, I'm here for just Roger Powell. For the
Just one?
Yes.
Okay.
And I'm not sure that Mr. Powell will be brought up here. It's my understanding he's in Gwinnett County. Custody there.
Okay, well, that'll streamline that one. Okay, and you are?
Attorney here, Sergeant.
Okay. But that's the only one you've got?
Yes.
Okay. Will Mr. Rao be able to stay, will you be able to stay here if Mr. Abate has to go to 1C, or you guys are there?
I'm sure we can tag team.
Okay,
Yeah, he can stay, I don't know how familiar he is with the case.
okay. We'll see. Currently, we have no defendants.
Yeah.
Mr. Mursajan, do you have a colleague who will be covering? We have 10 bond hearings, and in reviewing them last night, a number of them look like they would be appointed counsel. I know there's going to be one conflict issue because it's co-defendants, but I'm surprised you have only one, and you're lucky if that person's not here.
To my knowledge, Your Honor, I haven't spoken with any other attorneys about being here to bond, but I can reach out. and-
Okay. Great. Who typically covers this calendar?
We just have the clients are assigned to us, based on when they have their first appearance.
Okay.
So I would have had, Mr. Powell today, so it was.
Do you have it already? I have, but I don't have it together. Uh-oh.
Mr. Beatty hired private counsel, as I understand, so I was only here from Mr. Powell. The other, defendants should have their public defenders as they were assigned to them.
Okay, yeah, if you do a little outreach, that would be great.
Yes, I will.
All right, are there any attorneys here for bond hearings for someone whose name is not Kendrick? Yes, ma'am, you are here for whom?
I have Carl Washington and Daryl Williams.
So Carl Washington's been indicted and assigned to Judge Leffridge, so we will not be hearing bond for Mr. Washington today. What was the other one? Daryl Williams, I got that one. And you are? Can you say your last name again? Isola? How would you spell that? Okay, so once Mr. Williams is up, we'll try to do that one. Judge Leffridge. So that won't be heard today. That's just, he's been indicted. And so any issues or questions about bond will be covered by Judge Leffridge, to whom his case was assigned. So I don't even think he was brought over today. He may have been, but I won't be addressing bond because it's now assigned to a judge. Good morning, Ms. Clark.
Morning, Your Honor.
So you'll be handling the bond hearing for, assuming we get lawyers, for Kuykendall and McCaslin,
Yes, Your Honor.
as well as Mr. Tevis's client.
Tyreek
Yes.
Robinson.
Yeah. Pardon me?
I didn't receive a calendar for this date, I only knew about it because I looked up my Concept Odyssey. So I get a calendar and forward that to Ms. Woods.
Okay, let me get you a calendar. Ms. Nelson, can you text me to whom you sent the presiding bond calendar on the public defender side? Because it sounded like it might not have gotten over there.
I went to our team and so it
Meaning-
didn't go to any private attorney. I mean, it didn't go to the public defender's main office. It went to our team.
Meaning it went to Ms. Rios and Ms. Wood.
Correct.
Okay, I'll print you one.
Thank you. And additionally,
I got an extra copy.
Of the bond calendar?
Yeah.
Great, here it comes.
additionally, I did not file a bond motion for this hearing today, so that also may be why other public defender attorneys are not aware or not here.
Huh.
This
Well, we
was,
shouldn't be calendaring things where there aren't bond motions. We're gonna need to work on our process.
because my client has only been in custody for about 20 days and we haven't even had the hearing yet.
Well, that's what all these are, though. These are the ones where there was a bond deferral. So at first appearance, because of your client's charges, murder, and all these other folks, with one exception where it's a child sex offense or a rape or something, they're all murder cases. And so they never got a crack at a bond hearing. And so we automatically put them on these calendars. But you can say no thank you at this point. There's not a mandatory bond hearing.
Yes, sir, that was my plan to, well, not exactly withdraw the motion, but say we're not ready for a bond hearing at this time.
Okay.
On Mr. Powell's behalf.
Okay,
And I will reach out to the other attorneys and figure out.
okay. So I should take Powell off because you don't want to go forward with bond today. It'll stay with me. It's until indicted, bond hearing will be here. So if you want to defer the bond hearing to another day, that's good to know. I just want to make that notation.
Yes, sir, that's my.
Okay, thanks. Yeah. We'll see, but that may maybe go more quickly. Right, right. Okay. All right, so if there was anyone here for Mr. Powell and the deceased in that case is Mr. Woods, we're not going forward with that hearing today. And we'll see what other announcements we get.
Okay, wow, you're looking at the computer. What, I forget the attorney's name, but that seems to be the running theme of these, the positions today. There's no bond motions filed. Like in, for example, Mr. Drinkard, there's no bond motion filed.
Not even, sometimes there's just language to that effect with the first, when someone enters an appearance. I don't know what's triggering it, but we're gonna need to rethink our approach and just slapping everything down that got deferred for a hearing. And I think the default is you could not have had a bond hearing even if you asked for one, if you're Mr. Drinkard, just using that as an example, because of the charges. Mr. Drinkard, there are 2 decedents? Did I read okay. So, but that may explain why there aren't colleagues of Mr. Presiding here, that they weren't planning on arguing bond at this point. That was streamlined today.
Probably why there isn't an attorney listed on the calendar either. There's
Yeah.
a lot of them there.
So, that one we can do. He's one of the Powells, is Roderick Powell's your client?
Yes,
Do you wanna talk to him, or
I can speak to him for a moment.
we're skipping this, so he can go back down Roderick Powell. And we have a lawyer for Daryl Williams. Daryl Williams is here, okay, so we can do that. Daryl Williams and Robinson Baker are the ones that are ready to go. Do you have one of the? You're just a hanger on.
I'm a hanger.
That's what I thought, okay. You got nothing to do these days.
Right, no, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay, I got some
Good to
things.
see you, Judge.
Yeah, let me know. Could do some trials next year.
Can I talk for a second?
Yeah.
This might have been after your time. Did you ever go to University of South Carolina for the Trial Advocacy Center over there as a AUSA?
Yeah, a lot. That was where all our trainings were.
Right, right.
Yeah.
I went to school there, and last week, Victoria, she was a mock judge. They have the district court judges go down and help train, so I got to go back down there, and that was always on campus when I was there.
Yeah.
Towards the end of my time there, it was on campus, but I never really took note of what it was. It was just some fancy building that I knew nothing about.
Nice. Yeah.
Yeah. So
Yeah, because the residences are there, and there's a cafeteria, and then all the classrooms.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called the Graduate. It was a good time. So I got to take Hollis down and show them where I went to school and everything.
Excellent.
So, cool. Yeah.
Good family event.
Yep.
We've got Baker. Okay. Mr. Tevis, you ready to go? Ms. Clark, we're gonna do Mr. Robinson Baker. That's who we got. I'm just saying.
Yeah, that's all.
All right, Ms. Rivers, are you ready? Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for, and that'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case did not let him in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. You know, I know your background having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bonds?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
That's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank you.
Ms. Clark. Oh, Ms. Clark, before you go, you will come on, I have to tell you, good morning. I think Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have one prior misdemeanor conviction. It's in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't gonna be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
Good morning, Your Honor. Yes, Your Honor, there is an active
I can't hear you, it's odd, you're not muted.
warrant at this
Can't hear
time.
you.
Your Honor? Can you hear me? Okay. Your Honor? Can you hear me, Your Honor?
Other people can hear you, that's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
He is on
But if you
active
just wanna type in
probation.
the chat, whether there's a warrant, I'll relay that. He is not yet, he does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
Now,
that
Mr.
is-
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. The there's a young lady, Kim Yee, who actually was a friend of the victims at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other. And there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life, and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there is a friendship between the female that was assaulted. I think the roommate or something was also, he knows the defendant. So there are a lot of people that the defendant will have access to. And so for those reasons, I think that bond should be denied.
All right, thank you, Ms. Clark. So Mr. Tevis, you had asked to have rebuttal time. You certainly can have that. I'd ask you to include in there what more you can add, because I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in. That's getting more mysterious to me. And it's not dispositive here. Sure. I think the Cobb situation is for a temporary ruling that I'm going to make, but if you could clear up as best you're able, knowing that you're parachuting in as well, sure, what your understanding is with, hey, you should turn yourself in, I'm not turning myself in, however that played out.
Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple months were, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered him.
So ultimately, there may well have been before, I'm gonna call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and the police may have perceived that your client was reluctant. Right. It's not like he's under an obligation, but he was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this was someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand it, and that's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly, that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a dangerous community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, US Constitution. That's just not the case. Iowa is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not as positive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, in which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. And so I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you'd come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that?
No, sir.
Okay. Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. This would just be some kind of transport order, because he'll have to be released from this hold to get to Cobb.
Right. We'll work with Cobb on that so that then there's a hold put back in place. But we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this again. Okay. Very well. Ms. Clark, anything else?
No, Your Honor.
All right. Thank you. Do we have an update?
Yes, Your Honor, update on the defender cases for this morning. I have been able to get in contact with the other two attorneys who should be here for their clients. That's Mr. Pizzoli.
Okay.
He's presently in 2B with Judge Brooks doing preliminary hearings, so he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Pizzoli said he is ready for Hutchinson, McCaslin, and Drinkard.
McCaslin, now Drinkard, Drinkard. Okay, great.
And
Does he have a client where he's saying sort of like your client, we're not doing it today?
yes, that would be for Mighton and as well as Alvin Powell, position 5.
Okay, so Ruben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes, same house.
Defer, got it. And then you said there was a third attorney.
Yes, one more, Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She also, she's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams. That was the name, I still didn't get it. She was way in the back.
Okay, if Mr. Williams hired prior to them.
Okay, and did Ms. Jones have anyone else, or that was it? So Hutchison is Cazzoli, and he'll be here. Kuykendall, we don't know. McCaslin is Cazzoli, and he'll be here. Alvin Powell, we're deferring. Drinkard is Cazzoli, and he'll be here. Mighton, we've taken care of. You're Roderick Powell. And then we don't know about Beatty, but that may also be the young lady.
Beatty, yes, I know the Beatty is hired by the council, I don't know if that attorney is here.
Okay.
And I can also say that Kuykendall is a co-defendant of McCaslin, so she would be
A conflict defender.
conflict attorney. I don't know if they got those or.
Yeah, maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Daryl Williams? And did you say you also have Mr. Beatty? No, just, oh, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing pro bono.
Okay.
I filed a limited action for the purpose of bond.
Just for bond? Okay, got it. Thank you. What do you want to do? So we still don't have Kendrick. He's not up yet. Okay, so if we got Williams, why don't we knock that out? And then do we have, who else do we have up?
Hutchinson and McCaslin.
So McCaslin will be able to do, we'll be able to do both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Daryl Williams out, at least make progress? Uh-oh. Number 5. Number 8. Number 9. Yeah, but we don't do anything until someone reaches out. We don't have to proactively do anything. And then number 3 is a conflict defender case. So yeah, we can do that today. If she gets brought over, I'll let her know that what the situation is. Co-defendant number 4 as Cazzoli, and Cazzoli will be here. He'll be here later. You bet. All right, Ms. Rivers, are you ready?
Yes.
Okay, this is 24 PI 008200, State versus Daryl Williams. Good morning, Mr. Williams.
How you doing?
I'm okay. I'm Judge McBurney. I don't think we've met before, but we are going to talk about bond in your case. That's all we're doing today, just bond. And as long as there are bond issues in your case before it's indicted, that'll be in front of me. Once it's indicted, it's going to be randomly assigned. Could be me, could be a different judge. We'll see what the state's doing with the indictment. I need your lawyer to announce her appearance so we get that on the record. And spell your name now that you're closer to a microphone.
Last name is Iasello, Iasiello.
Iasello, Ms. Iasello, thank you for being here for purposes of bond. Mr. Abate, are you handling this? Okay. Mr. Williams, you're charged with murder. You were originally charged with aggravated assault, and Mr. Clark passed away, so that was upgraded to murder. And I'm going to hear from Ms. Iasello why you should get a bond and in what amount. Then I'm going to hear from Mr. Abate about what the state thinks about bond. And let me pause for 1 minute. Ms. Clark, you were going to give me a victim impact statement, but when we have another hearing on Mr. Robinson Baker, make sure you do that. All right, Ms. Iasello, when you're ready. I think it's easier for Ms. Rivers to hear you if you do that. Thank you.
Good morning, Your Honor. Thank you for the opportunity to present this bond argument on behalf of Mr. Daryl Eric Williams, a man who stands before this court accused of a serious charge, murder. While the charge is significant, Mr. Williams is presumed innocent, and the purpose of bond is not to punish, but to ensure his appearance in court and protect the community. We respectfully submit that Mr. Williams is not a flight risk, is not a danger to the community, and is not a risk of committing new offenses or obstructing justice. Under Ayala, these 4 factors guide the court's decision on bond, and the facts of Mr. Williams' case support the granting of bond. In addition, I must bring the court's attention to Mr. Williams' significant and urgent medical concerns. Mr. Williams suffers from chronic kidney disease, is a kidney transplant recipient, is diabetic, and also suffers from neuropathy. These conditions require regular medical care, specialized medication, and monitoring that the Fulton County Jail is ill-equipped to provide. Denying him bond under these circumstances would expose him to substantial and unnecessary risk to his health. Lastly, it is critical for the court to know that Mr. Williams is the person who called 911 during the incident that led to his arrest. This act of seeking help does not align with the actions of someone trying to flee, evade, or obstruct justice. Due to a miscommunication with responding officers, Mr. Williams was charged. We are confident that as the facts unfold, the charges will be reconsidered, but in the meantime, we ask that the court grant him a bond so he can receive the medical care he urgently requires. The first Ayala factor asks whether Mr. Williams poses a risk of flight. The evidence clearly shows that he does not. Mr. Williams was the 911 caller and not a fleeing suspect. The most compelling evidence that Mr. Williams is not a flight risk is the fact that he is the person who called 911 and was not fleeing the scene, hiding, or attempting to avoid law enforcement. Instead, he actively sought help and remained present as officers arrived. As I stated, Mr. Williams' health condition makes it impossible for him to flee. He is a kidney transplant recipient and requires ongoing medical care, including strict medication schedules, metformin for his diabetes, and treatment for neuropathy. Any interruption to his medical regime could have catastrophic effects on his health. He has every reason to stay near his medical providers and avoid life-threatening risks of being on the run. Mr. Williams is deeply rooted in this community. He's the father of 4 children, 2 adult daughters, and 2 young boys. He volunteers with food distribution programs to give back to those who have less than him. His friends care for him so deeply that they reached out to me when they were unable to find him around Thanksgiving and subsequently located him on the inmate roster at the Fulton County Jail. I agreed to handle this hearing pro bono because I was moved by the love and concern of his friends who were desperate to help a man they described as thoughtful, generous, and kind. Mr. Williams has no history of failing to appear for court proceedings. He has shown compliance with all legal obligations and has no pattern of attempting to evade responsibility. The second Ayala factor asks whether Mr. Williams poses a danger to the community. Here, there's no credible evidence to support such a finding. Mr. Williams does not have a serious prior history of violence or any criminal history involving firearms or weapons. The court is not being asked to evaluate a person with a pattern of dangerous behavior. It's also worth noting that Mr. Williams is 61 years old and does not have a history of weapons charges. Mr. Williams' role as the person who called 911 is critical to this analysis. His actions show that he sought help, not harm. The fact that the charges rose from a miscommunication with responding officers should be carefully considered. If the court has concerns about community safety, Mr. Williams is willing to submit to restrictive bond conditions, including curfews or electronic monitoring and pretrial check-ins. As far as the third IALA factor, risk of committing new offenses, Mr. Williams does not have a pattern of repeated offenses. His record shows that he has been a law-abiding member of the community. He does have a pending battery charge from July, but as that case unfolds, it will be clear that he was defending himself from attack. Mr. Williams' primary focus is his health. Managing kidney disease, diabetes, and neuropathy leaves little room for anything else. His medical condition creates a natural structure in his life that drastically reduces the likelihood of reoffending. If there's any doubt, like I said, he is willing to submit to restrictive bond conditions. And there's no indication that Mr. Williams would interfere with the administration of justice. He has no history of obstructing justice, tampering with witnesses, or evading legal obligations. And it bears repeating that he is the one who actively invited law enforcement to the scene and was not attempting to flee. And again, I would emphasize Mr. Williams' urgent and unique health needs, which the Fulton County Jail, frankly, does not have the capacity to address or provide the level of care that he requires. And therefore, I would suggest that denying bond in this case would prove to be life-threatening for Mr. Williams. We request a reasonable bond that is aligned with Mr. Williams' financial means. He is on a fixed income from disability and faces eviction soon based on the fact that he's been incarcerated for a month and has fallen behind on his rent during that time. I'd ask the court to consider a bond not to exceed $25,000. I recognize that the charge is very serious, but he does have very limited financial means, and we would be amenable to any restrictive conditions the court sees fit to impose. In conclusion, I would submit that the 4 IALA factors weigh in favor of granting Mr. Williams a bond. He is not a flight risk. He is not a threat to the community. He has no risk of reoffending, and his medical needs create an urgent and compelling reason for his release. For these reasons, I respectfully ask that Mr. Williams be granted a bond. Thank you.
Right. We'll have one question, and then there may be follow-up from you after we hear from the state. Is it your understanding of the situation that Mr. Williams was on the outside allegedly shooting in, or he was on the inside allegedly shooting out, if you know anything about the situation?
So my understanding of the situation is that Mr. Williams was in his home and heard shots outside his house and called 911 from the inside of his residence.
Okay. All right. Thank you.
Good morning, Judge.
Good morning.
The state would respectfully request you deny defense counsel's motion for bond for several reasons. The first being that the defendant does have 3 prior felony convictions, making him an A and C recidivist, in the sense that if convicted after trial, he'd be facing a mandatory life without the possibility of parole sentence. Furthermore, the state would submit to the court that the defendant is a risk of flight due to the strength of the case, in that Mr. Williams is seen on the ring camera waving a gun around after he shoots it through the door at the victim, who was inside of his home, who was struck in the face and ultimately dies.
So that was what I was asking Ms. Iasello about. Mr. Clark is the decedent.
Yes, Your Honor.
Mr. Clark is in his home, or he is in Mr. Williams's home?
Mr. Clark is in his home, and
Meaning Mr. Clark's home?
Mr. Clark's home, yes.
And what you say that the ring cam video would show is that Mr. Williams would be outside the door, not of Mr. Williams's home, but outside of Mr. Clark's home.
That is correct.
And shoots into Mr. Clark's home.
That is correct.
Okay.
And actually shoots through the door and strikes Mr. Clark on the left side of his head. Ultimately, police are called and medical attention is attempted, but about 20 days later, he does succumb to his injuries due to being shot in the head. So I would submit to the court that he is a threat or danger to people in the community in it, as he shot Mr. Clark through his own door, unarmed at the time, and posing no threat to the defendant, excuse me.
Ms. Iasello indicated that Mr. Williams was the one who called the police and that he stayed on scene. Is that your understanding of the facts?
He is one of 3 people who called the police. He is actually the 3rd individual who called the police. The first 2 described that Mr. Williams was outside of the doors of not only their apartments, it's a 4-unit apartment building or home. And he was.
Is Mr. Williams one of the 4 occupants?
That is correct, Your Honor.
Okay, so he's around his own space, may not have been his door, but it wasn't that he lived across town and came to this place.
Correct.
Okay.
Outside of their doors, screaming threats at all parties who were around and living in the apartment building. So 2 individuals called, 2 females called 911 indicating that, and that they saw Mr. Williams outside their doors and the door of Mr. Clark waving the firearm, and then heard a single shot. Mr. Williams did then call 911 and was incoherent, I guess is the best way to put it. He was under the influence of something would be what the state would submit to the court, and he indicated that someone had just shot his brother. And I can clearly state to the court that Mr. Clark is not Mr. Williams' brother. And he did remain on scene. Upon the officers arriving, he did admit to shooting Mr. Clark through the door. So I can agree with defense counsel as it relates to that. So based on all the factors, Your Honor, and all the totality of the circumstances, the state would submit to the court that at this time, Mr. Williams is not a good candidate for bond and should remain in the custody of the Fulton County Jail.
Do you have any information, I don't know that they'd be reaching out to you, I'll be doing some outreach about the jail's ability to tend to Mr. Williams's health needs?
I don't. I can obviously reach out to whoever needs to be reached out to. I neglected to inform the court as well. The incident that occurred on that defense counsel had referenced that Mr. Williams was out on bond for. It was an assault from July of this year. It was actually an assault on the same victim.
Mr. Clark?
Yes, and there are eyewitnesses who watched Mr. Williams out of nowhere begin to attack Mr. Clark as he sat on the porch and was defenseless at that point as well.
All right, thank you. Ms. Iasella, I'll hear from you again. I forgot to ask Ms. Jackson from Pretrial Services about Mr. Williams's criminal history. It sounds like Ms. Jackson, Mr. Williams has some convictions. I'm curious how old they are, if they're from the 1990s or if they're from 2 years ago. What information do you have?
Okay, they're from the 90s, Your Honor. He has 18 cycles. The last arrest was July the 19th, 2000.
They're all, majority of them from the late 1990s. The most recent one is from 2002. It's a terrorist threat out of the DeKalb County.
Okay. Ms. Nelson or Ms. Hansberry, can you call IT so we can figure out why we're not able to hear folks who have dialed in? It sounds like it's not just a probation issue. I mean, there's clearly something going on in the courtroom, but we weren't able to hear Ms. Jackson. Thank you.
Can you hear me now, Your Honor?
Ms. Iasella, I would like, with your client's permission, to be able to talk with the jail medical staff. They'll be more candid with me if Mr. Williams says, hey, you can talk to Judge McBurney about this. Yeah, that's me. This seems different, but because it's clear, like we see the little microphone is showing that it's receiving things, but it's not coming out of the podium. But you may be right. Oh, those aren't working either. Okay, so it's just fine. Thank you. So
Mr. Williams is fine with you contacting.
okay, and Mr. Williams, I'm not trying to pry into your personal medical situation, but it's important that you get the care you need regardless of these charges. And I need to balance whether that can happen while you're in custody or if you need to be out on bond for that. So that's helpful, and I will reach out to the doctor who manages the healthcare at the jail. Was there anything, Ms. Isola, you wanted to add or respond to?
Your Honor, I've not had the opportunity to review the ring footage, so I can't speak to the accuracy of the of counsel's characterization of that. But you know, I would submit that Mr. Williams was obviously in his home. He did not flee the scene. He is committed to fighting these charges and clearing his name, and I do believe he is a good candidate for bond.
Okay. Your entry is for bond. Is it as long as we're going back and forth about bond, or it was for today? Okay, all right. Mr. Williams, I'm not going to set a bond at this point. I need to talk with the doctor at the jail to better understand how the jail might be able to or might not be able to support your health needs. In the interim, I guess, I'm fine requiring the state to get the ring camera footage to you, even though you won't necessarily be the lawyer long-term. It's certainly helpful. They're not obligated to do that, but I often ask when the state is particularly reliant on something in a bond hearing to get that to the other side.
I would appreciate that, Your Honor.
Okay, great. Mr. Abate, would you be able to get to Ms. Isello the ring? Oh, he's gone. Mr. Rao, would you be able to get the ring camera footage? I don't mean right now, but just in the next few days, get that across to Ms. Isello.
Absolutely.
Is he coming back?
You should.
Okay. Do you have to go down to 1C?
I believe so.
Okay. It's that kind of day.
Yeah.
So do you have any questions about what I said, Mr. Williams?
He wants to ask a question.
Okay, what's your question, sir?
I see. If we got jail, they're not gonna. I mean, I already know that because the day I tell this my kidney, okay, she was saying that that new thing showed that my kidney was good, but I've been at a transplant, okay. All right, my brother gave me a kidney. And they just looking in that way for people, you know what I mean? They just gonna do that, yeah, for people like that.
Okay, well, that's what I'm gonna talk to them about. And are you on dialysis, or because you have a new kidney, you're not on dialysis?
See, I go back for Tennessee. I gotta go back for every 3 months.
Okay.
To be put on, they call that, extra dollars, okay? Like, you know, I don't build it like, you go out like that, build it like overnight.
Okay.
Out, you know.
Well, I'll talk with the doctor, and then I will certainly let your lawyer and the prosecutor know, okay?
Okay.
You're welcome.
What time?
All right, so do we need to take a break so you can move people up and down, or do we have other people up who can handle it? Okay, we'll do that.
Thank you.
Mr. Rao, are you handling this or do we need Mr. Abate back? You're handling, okay. Let's get one thing up here on the screen. All right, Ms. Rivers, are you ready?
Yes.
Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick.
How you doing?
I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that the facts did not arise to an aggravated assault, but a battery. And I know that, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. There'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, you know, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Daryl Williams, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault, I'm gonna call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage, but they were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. And every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations. Or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
is
correct.
Your best forecast with maybe one exception.
That's correct.
Okay, all right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation, hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimberly. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed or if it's lifted or it's dismissed or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter or is this our universe? The assault case and the contraband case.
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for, because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's gonna do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're gonna deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone, this time it was a cheeseburger. Let's just wrap it all up if that's what's gonna happen. And I trust Mr. Rao is gonna look into that, and they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay, and we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015, because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state? Yeah. All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here. All right, we're going to just figure out what's next, but we'll take a break. I just need to know what is remaining.
Everybody else up, right?
Yes. Excellent. Thank you, gentlemen. Maybe we can. She is? Okay. Do you want to, would it be helpful that the Miss Kuykendall, we can't handle today, but I could tell her that and then you guys can take her down. I'm assuming that's complicated to have her up here. Okay, why don't you just bring her right to the door?
Yeah, I've not heard anything from Mr. Pizzoli since he said he would try to get here as soon as he can.
Okay. Is he the only lawyer down there? I don't remember if it's divided up and there are. Okay, all right. Well, I may reach out to Judge Brooks to see if we can have her put all this stuff up.
Yeah, Judge, and I was about to offer, I could just run down there myself and see Mr. Pizzoli.
Great, that'd be helpful, thank you. And did you want, you have spoken to Mr. Roderick Powell?
Yes.
So he can go?
Yes.
All right, thank you. Are you Ms. Kuykendall? Hey, I'm Judge McBurney. Your case has been assigned to me for bond, just for bond. But we need to get you a lawyer. Mr. McCaslin has had the public defender appointed to represent him. And I'm assuming you want a lawyer appointed to represent you, but it can't be the public defender because you're entitled to a lawyer who is independent and represents your interests and only your interests. So we have what's called a conflict defender who gets involved when they're co-defendants. because the public defender can only represent one of the two. And so I'm working to get that conflict defender assigned to you so that she or he can then come before me with you to talk about bond. But we don't have that person today. So once we get that lawyer, we'll set this back down for bond, have you come over here. Are you at the city jail? Are you at ACDC? So we'll get you back from there to have that conversation about bond. But we weren't able to line up the conflict defender for today. So I wanted you to know why you were brought over. It was to talk about bond. I just didn't know which of the two of you, McCaslin or you, had the public defender. Turns out it's Mr. McCaslin. But we'll get you your own independent lawyer who will then talk to you about bond, okay? I don't know, I'd like it to be this week. That would be great. But this case will be mine for bond until it's indicted. So if it's not this week, it'll be as soon as we can get you and that lawyer back here. But it needs to be soon because you're entitled to a bond hearing. I don't know that you'll get a bond, but you're certainly entitled to have a bond hearing. But that requires that lawyer. So we're working on that right now. Okay? Thank you. So, Ms. Clark, we will do McCaslin once Mr. Cazzoli gets here.
Okay.
And then Mr. Rao slash Mr. Abate, we've got two others we can do once Mr. Cazzoli gets here. Mr. Beatty supposedly, is Mr. Beatty up?
Yes.
If we could bring him to the door, he supposedly had, let me see if it's in the system. Someone said he's got a lawyer. Hired someone. Hey, are you Mr. Beatty?
Yeah.
Hey, I'm Judge McBurney. You were brought over today because we were going to talk about bond. But it looks like, did you or your family hire a lawyer? Ms. Baker or Mr. Attorney Baker?
Yeah.
Okay, I'm gonna see if we can get that person here. Is that a male or a female? Female. I don't think she got notice of this calendar because she filed her entry of appearance after the calendar was published. So I had the public defender here because real briefly you had the public defender. So we're gonna reach out to Ms. Baker. If she cannot be here today because she might be in court somewhere else, once we can get her in court, I'll bring you back here so that we can talk about bond. I just wanted you to know why you got brought over today. We just didn't know that Ms. Baker was your lawyer. Okay, any questions about that? That happened in jail?
Yeah, yes, sir.
The other arm too? Okay, all right. So, we're gonna take a break until we can get Mr. Cazzoli up here. What case are you all here for? Pardon me?
Hutchinson.
Okay, that's one of Mr. Cazzoli's cases. So we'll certainly do Mr. Hutchinson, and we should be able to do it this morning if we can pry him out of that courtroom. Is there anyone here for a different case? Sir, which case are you here for? McCaslin, okay, also with Mr. Cazzoli, and we'll do that one as well. Are you here just for McCaslin, or were you also here for Kuykendall? Both. Are they married?
No.
Was the child both of theirs, or just Ms. Kuykendall? It was mom and dad?
Yeah.
What's your connection to them?
I'm his father.
Mr. McCaslin's father? Okay, thank you for being here. All right, so that's our plan. We're gonna try to get the defense attorney in here. Mr. Rao, are you able to do those other cases, or we'll start, since we have Ms. Clark, we'd start with McCaslin, so you don't have to climb uphill. Is Mr. Abate coming back, or should we just?
I texted him, I will go back to my office and at least try and get an understanding of what.
Okay, we got some time. We'll figure out what's happening with Mr. Cazzola.
Yes, sir.
All right.
Oh, yeah. So how long would it be?
How long do you need it to be?
Just need to draw some.
Yeah, you can do that. We can't go until we get that. We're missing a defense attorney, so we'll just pause for now. Sure, there's a, oh, that's the badge. Okay, yeah, I'll go back and read those. I'm gonna look at your warrants now. No, you stay there, I gotta go read them.
Yeah.
That means a father.
Thank you. You good? All right, be safe. Mr. Rivers, are you ready?
Yes.
Okay, going on the record in just a moment. Let's see if those cameras work now. Oh, okay. Are the screens off, Deputy Gordon? Or
It's just you on screen.
All right, lucky them. Okay. This is 24 PI 008680, State versus Ricky Hutchinson. Good morning, Mr. Hutchinson.
Good morning.
I'm Judge McBurney. Your case has been assigned to me just to talk about bond. So Mr. Cazzoli will represent you for bond. If your case gets indicted, it will probably go to a different lawyer from his office. We'll probably go to a different judge in this courthouse. It'll be randomly assigned, and that judge is going to have his or her own public defenders who work in that courtroom. But as long as what we're doing is talking about bond and you haven't been indicted, then Mr. Cazzoli will be helping you with that, okay?
Yes, sir.
I'm going to hear from him in just a moment about why I should set a bond for you and what that bond should look like. And then I will hear from Mr. Abate, who is the prosecutor, who right now, Ms. Johnson, you need to mute your phone, about the state's perspective on that. And I'll let you know what I'm going to do. If I do not set bond, that doesn't mean we can't talk about it again in the future. If I do set bond, then you and your family will need to figure out how to make that bond. Mr. Cazzoli, when you're ready.
Thank you, Your Honor. Your Honor, Mr. Hutchinson is 21 years old. He has a good address at 2405 Spring Creek Lane, apartment 2405. That's going to be in Lithonia, Georgia. He lives there with his aunt. He was born and raised in Georgia, Your Honor. He had 2 jobs at the time of his incarceration, and he has been able to confirm to me that those jobs are still available to him upon release. It's going to be at Quick Draw Towing, and he also works as a cook at Culinary Drive. Culinary Dropout. Your Honor, he is a high school graduate. He's also attended trade school at IBW. Your Honor, my understanding is that Mr. Hutchinson has limited to no previous criminal history. Your Honor, I would be happy to hear from pretrials if that is not the case. So our request, Your Honor, is for a reasonable bond to be set here. Again, there's nothing in his history that indicates he's a general danger to the community, a general danger to the victim or the victim's family. Him being a lifelong resident of Georgia, Your Honor, there's nothing in his history to indicate that he is someone who will flee the jurisdiction. So we believe, Your Honor, he is entitled to a bond based off those factors. Our request, Your Honor, will be a bond of $75,000. We're going to be requesting, Your Honor, $50,000 on the murder charge, $15,000 on the aggravated assault, and $10,000 on the firearm charge. Nothing further.
Okay. Ms. Jackson, I think we've fixed the volume issue here in court. Can you share with me, please, criminal history information for Mr. Hutchinson?
Yes, Your Honor.
You sound great.
Can you hear me, Your Honor?
Yes, you sound great.
Okay. He has 4 cycles. The last arrest was September 6, 2024 in Douglasville, Georgia for a probation violation. He does have a misdemeanor conviction and a sentence. It's one in 2023 out of Conyers, Georgia for a non-fingerprintable offense, and one in 2023 who received a nolo contendere sentence out of Douglasville for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you so much. Mr. Abate.
Yes, Your Honor, I had the same similar criminal history. The defendant has a minimal criminal history as it relates. He has no felony history, and the history that he has is all misdemeanor arrests. I do, as it relates to risk of flight, he does have in his GCIC one failure to appear that was fairly recent in May of 2023 in Douglas or Douglasville. But it appears that has been resolved. Your Honor, I would submit to the court that based on the facts and circumstances of this case, the defendant is a risk as it relates to the community and the people within it. Based on the circumstances of this case, on November 24th of this year, the defendant, his friend, Mr. Devon, had gotten into an argument with the victim. There was a physical altercation. The victim in this case was unarmed, and it was merely, fist to fist. This defendant decided to pull a firearm out and begin to obviously shoot at Mr. Johnson, killing him on Crescent Avenue here in the city of Atlanta. Upon officers,
Crescent, as in Midtown?
Yes, Your Honor. There was a nightclub, one of the nightclubs that's off of Crescent. They were all waiting in line. The associate of the defendant, Mr. Devon, after speaking with the police, didn't believe that there was any need for any additional force that he had to taken care of, is basically what he said. And he actually said during his interview that he didn't believe that the victim actually posed a serious threat, as he was intoxicated as well. And that the use of force that he saw his friend use as it relates to Mr. Johnson shocked him, and he was unaware that he actually had a firearm. So the state would, based on the facts and circumstances and the fact that this defendant took it within his power to, in the middle of the street, fire a gun around a crowd of people at this time, makes him not an appropriate candidate for bond.
And I appreciate this is all very preliminary, and Mr. Cazzoli's probably seen zero evidence in the case, but what is it about the facts that you believe connects Mr. Hutchinson to the shooting? It would be Mr. Devon, the eyewitness, saying, look, we were all standing there and there was this dispute between Johnson and Hutchinson, and here's how it ended.
That, Your Honor, as well as there is some video surveillance evidence. The actual shooting is not on video surveillance, but within seconds of the shot being fired, there were several City of Atlanta police officers who were working off duty at the surrounding clubs, and they immediately surrounded the defendant, and he was actually arrested and captured with the firearm, physically in his hand.
Good.
And when Your Honor deems appropriate, as you're aware, Ms. Johnson, the mother of the victim, is on the Zoom and would like to make an impact statement to the court.
Of course, that is very appropriate. And Ms. Johnson, if you want to unmute now, and if you turn your camera on, I'd appreciate hearing from you about your thoughts about bond for Mr. Hutchinson. Thank you for being with us.
Yes, sir. I just wanted to say thank you for letting me have this time to speak. My son was 28 years old. He's never been in any trouble. He came down there to have a nice time with his girlfriend, brought her down there for her vacation, for her birthday.
When you say, I'm sorry to interrupt, but so your son was from out of town or just from outside of Atlanta?
Yes, we from Memphis, Tennessee. We stayed in Memphis, Tennessee. I've been working for FedEx for 23 years. He followed in my footsteps. He worked for FedEx when he got out of high school. I never had to go to the school for my son. He's never been in any trouble. And I just don't know what happened that night, but I just feel like, that he doesn't need a bond.
Okay. So your son was in town with his girlfriend. They were just enjoying things, taking a break from Memphis. And that's when this happened.
Yes, sir.
Okay. Well, I'm very sorry for your loss, but I also very much appreciate hearing from a family member and getting that perspective. Thank you.
Thank you.
You're welcome.
Nothing further from the state, Your Honor.
All right. Mr. Cazzoli, I always give last word to the movement, and that is you. Anything you want to say in connection with what you heard from Mr. Abate or anything else that you wanted me to hear?
Just briefly, Your Honor, I did just want to note for the court that Mr. Hutchinson has his preliminary hearing tomorrow. You were correct in saying that I have not seen any of the evidence discussed today, even the evidence provided by the state statement. I have not heard. My knowledge of the incident is just the probable cause section of the warrant at this time.
Sure.
So, Your Honor, at this point, these remain accusations and they remain testified to through a warrant, but with no chance of cross-examination at this time, Your Honor. And more importantly, Your Honor, we believe that the ILL factors must speak to something other than the allegations for which Mr. Hutchinson is here for today. I will note, Your Honor, that Mr. Hutchinson also does have family present as well and support.
Yes.
Nothing further.
So they've been here all morning, and I appreciate that, and that's a good sign. Mr. Hutchinson, I'm not going to set bond at this point, but I am going to invite Mr. Cazzoli to circle back after tomorrow's preliminary hearing. I think he will understand much more about the facts and circumstances of what happened on November 24th. I will tell you that what I'm most concerned about is the notion that it sounds like there's going to be self-defense. And that's what I suspect you'll be exploring with the officer and whatnot. And so we'll need to suss that out a little bit further. It could reach the point where there's an immunity motion filed. But until I hear a little bit more about that, I'm hearing about one gun being recovered on Mr. Hutchinson and not a whole lot else. And that gives me pause about Mr. Hutchinson's safety and the safety of those who might be around him if there is some disagreement about something. I don't find that he's a risk of flight. I'll be clear about that. But based on what I've heard, I want to let the preliminary hearing play out and then give you a chance, Mr. Cazzoli, to circle back if you think there was evidence that came to light in those proceedings that you think I ought to see or hear. I could read the transcript, or I'm happy to rely on representations by counsel on both sides. Mr. Abate won't be the one doing the prelim, but there will be an attorney there. And if after that prelim, there are things you want to share with me, an email to me copying whoever your counterpart was at the prelim and Mr. Abate, it can be that simple to say, Judge, you should know X, Y, and Z. Then I can figure out how to get a transcript, or we can reconvene. I don't mean for this to necessarily be a forever answer. And I want to add this, Mr. Hutchinson. The state has a certain number of days by which to indict you. And if they do not do it by that date, then you are entitled by law to a bond. So my concerns that may persist, it may be after the prelim tomorrow, Mr. Cazzoli says to you like, this one's kind of complicated. You're absolutely entitled to a bond if we reach that 90-day point and there's no indictment. That would again come back to me, and we'd work through that. And Mr. Cazzoli would be reaching out before day 90 to say, hey, we're at day, I'm making it up, we're at day 80 and there's no indictment. So please get us on a calendar so you're not waiting after day 90. We get it on the calendar, and it would just come off the calendar if it does get indicted, because then this question about bond would go to whatever judge your indictment is assigned to. Does that make sense?
Yeah, I have one question.
Sure, as long as it's not about the facts of the case.
Okay, so after the preliminary hearing tomorrow, there is a chance I could get bond?
Sure. Mr. Cazzoli will know more about the facts, and he will be in a better position to say, I heard what the state said, but what you didn't hear from all that was, I'm making this up, Mr. Hutchinson was shot twice before he did anything. That's a very different scenario from what I'm hearing, and I'm not making any factual findings, that there's a disagreement, maybe they're shoving or pushing, and all of a sudden one guy pulls out a gun in a fist fight. That's concerning. You can understand why I'd be concerned if those are actually the facts. And Mr. Cazzoli, through no fault of his, he's not able to push back on that yet because he hasn't had a chance to talk to anyone about it. Tomorrow, there ought to be a detective there that Mr. Cazzoli can ask questions of. Well, what about this? And how did this play out? And so your lawyer will then be in a better position to say, Judge, there's more to the story than what you heard. Okay? So yes is the answer. It's a long way of saying yes, that we can revisit it. And even if after that hearing, you and Mr. Gazzoli talk, and Mr. Gazzoli says, it's just, that didn't go real well for us. You know, all the evidence was that you shot this guy, I'm again making it up, you shot him in the back. That's kind of hard to argue self-defense. If it gets to day 90 and you're not indicted, no matter whether the case is good, strong, ugly, or upside down, you're entitled to a bond. So there's also that maximum deadline where if it's not indicted, we have to reconvene, and I'm required to set a bond, which of course I'll do. I'll do what the law requires. At this point, I'm going to table it and not set a bond for you. We'll let you and Mr. Gazzoli get through the prelim, and then if Mr. Gazzoli thinks that we ought to discuss this further, it could just be emails, it could be he wants you to be in that loop, and then we'll get you back in court, or he can always waive your presence in this sense. You'd zoom in, so you'd be able to see and hear, you just wouldn't physically be here. You'd be in one of those Zoom booths out of the jail. Okay? Did that answer your question? All right. Pardon me? Sure.
Thank you.
You're welcome. Thank you. You unfortunately, no contact. You can wave, do the heart. You guys are a good support group. You should come every time you hear that he's in. I'm serious. Every time you should come to court, whether it ends up being my case or not. It tells the judge a whole lot that there's support, because I'm thinking about who's going to make sure he stays out of trouble if he gets a bond, and I see 6 folks who are going to do that. So thank you for being here.
Thank you.
All right.
Have a great day.
You too.
Thank you, Your Honor.
Yes, Ms. Johnson, and same with you. You are entitled to appear virtually or in person, and the DA's office will let you know whenever there is an event in connection with this case, because you're entitled to be heard as well. And I appreciate you appearing virtually today.
Yes, when the trial come, I will be there, Your Honor. Thank you so much.
All right, take care.
Bye-bye.
We're awfully festive for no bond. So we're gonna do Mr. McCaslin next.
Your Honor, do you know if Ms. Kirkendall was heard today? That's his co-defendant.
I do know. We're ready for McCaslin when you guys are ready. I met her, but she needs a conflict defender, and so I explained that to her, that Mr. McCaslin had been appointed the public defender, so she's entitled to an independent set of eyes and ears. And the way this calendar unfolded, we didn't know which of the 2 your office was representing, and so no notice was given to. I don't know who's your conflict defender counterpart for all the busy work you do.
So in terms of the organization, Your Honor, or the
yeah, like is there a particular, like it's always Sam Smith who handles the.
I wouldn't be able to say in terms of Superior Court. We typically have Cindy Gibson or Hannah Rondon in preliminary non-complex court. I think one of them will typically take the more serious crimes as well, though.
Okay, just for purposes of bond.
Yes.
Yeah, I think I've had Ms. Gibson appear before. We'll figure it out, but we need to get Ms. Kuykendall, that lawyer, so that person can advocate on her behalf. All right, let's get on the record. This is 24 PI 008684, State versus McCaslin. Mr. McCaslin, I'm Judge McBurney. Your case is in my division just for purposes of bond. And so anytime we need to work through bond before you're indicted, it'll be Mr. Gazzoli, and you and me, and a prosecutor, probably Ms. Clark, who's seated over to your right. But that's all we're working through today is bond. At some point, you may get indicted, and then your case will be randomly assigned to one of 15 different judges. I'm one of them, so I might get it, but it's a 1 in 15 chance. If I do not set a bond today, when you get to that judge who's going to have your case indictment onward, meaning on through trial or plea or however your case is resolved, That's another opportunity for your lawyer, and you'll have a different public defender once you get assigned a judge, once you get indicted, for you and that lawyer to say, Judge, we need to talk about bond. Okay? All right. Mr. Cazzoli, when you are ready.
Thank you, Your Honor. Your Honor, Mr. McCaslin is 34 years old, my apologies, Your Honor. He has a good address at 2741 Old National Parkway. He's been living in the metro Atlanta area for the last 4 years, but has been living in Georgia his entire life. Your Honor, he has a good job. He's been doing maintenance for the Alexandra Property Group for some time. Your Honor, he has 7 children, ages ranging from 1 to 15 years. Your Honor, my understanding, again, at least in Fulton County, no felony convictions. My understanding is he is not on probation, not on parole, another very limited criminal history. I will note, Your Honor, another contrast here, and again, not to get too into the weeds before there's a preliminary hearing, but the allegation here, Your Honor, does appear to be that of murder in the second degree, based off of a cruelty to children in the second degree. The allegations, at least, are that a child unsupervised consumed a harmful substance and unfortunately passed away. Your Honor, I think that, again, we have not been able to parse out all the facts and figure out exactly what there's probable cause for or not. But I will certainly say, Your Honor, in terms of intent to harm, Your Honor, that's a very different picture than.
Right. My understanding is, just to cut to the chase in terms of the factual allegations, and right now there are only allegations. Mr. McCaslin is here with the presumption of innocence in his favor, that Mr. McCaslin and Ms. Kuykendall had at least one child shared in common. That child got access to methamphetamine and cocaine, I think it's in a hotel room, that Mr. McCaslin and Ms. Kuykendall occupied, consumed that methamphetamine and cocaine, and died from overdosing on those drugs. Probably not the kids' drugs, probably the adults' drugs, whether they were for personal use or for sale. But it is a very different category than you shot someone in the head, you shot someone in the chest, you stabbed someone. It's tragic, it's reckless, it's irresponsible, if those are the facts. But just to get to your intent point, I didn't see anything in just reviewing the case file that suggested that this was an outcome anyone was looking for.
Yes, Your Honor. Thank you, and that's a good summary of my position here. For that reason, Your Honor, and again, and you briefly touched on it, but the fact that there is a co-defendant in this case adds kind of another layer of complication in terms of determining fault. Again, that's something that's going to be handled at a separate time, but we do just ask that the court consider that as it relates to the IALA factors, as it relates to likelihood to to commit new felonies, as it relates to danger to the community and persons. And Your Honor, in his his strong ties to the community, again, he's been an Atlanta resident almost as long as I have. He's been a Georgia resident his entire life. So Your Honor, our request would be a bond not to exceed $40,000 on the murder charge, 10 on the cruelty to children charge, and 5 on the VGCSA.
So is it 55?
55 total, Your Honor, would be our request.
All right. Mr. McCaslin, you said had 7 kids. That's excluding the deceased?
Your Honor, I believe that may be including the deceased.
So you have 6 surviving kids.
Yes, Your Honor.
All right, and they are where right now?
My youngest 1-year-old is with my co-defendant's mother.
Okay.
And the other 5 are with their mothers.
Okay. And when you were not in custody and Ms. Kuykendall was not in custody, it sounds like you and Ms. Kuykendall had 2 kids who stayed with you?
Yes.
And then your other 5 would have been with those children's mother? You might see them from time to time, but home for them was their mother's.
Yes, sir.
But active in your life on a regular daily basis would be?
We was in the hotel room, so we had been struggling since Corona.
Okay, but staying with you in the hotel room, 2 kids?
Plus my nephews, I have custody of my sister's kids.
Okay, how many kids is that?
2.
2. So you had 4 kids in the room with you?
Yes, sir.
All right. 2 of them are yours and Ms. Kuykendall's, and then 2 are your sister's kids.
Yes, sir.
Okay, got it. All right. Thank you. Ms. Jackson, can you share with me any criminal history information you have for Mr. McCaslin?
He has 14 cycles. The last arrest was June the 11th, 2024 in College Park, Georgia, for driving while licensed suspended or revoked. There was no disposition for that arrest. He does.
I can't have pork or red meat.
Hold on one second, that's someone else. Shut that down. Okay, sorry about that.
Okay. He does appear to have an open case pending in Fulton County for theft by receiving stolen property. That case number is 24 PI 003210. And he did receive first offender treatment for a felony in 2010 for burglary and possession of tools for commission of a crime. That case was sealed February the 14th, 2018. And he does have a misdemeanor conviction and a sentence. He received a nolo contendere sentence in 2018 out of Gwinnett County for driving while licensed suspended or revoked. And there was a conviction in 2017 out of Liburn, Georgia for a hit and run and driving while licensed suspended or revoked and acquiring a license plate for purpose of concealing. Nothing in addition, Your Honor.
Thank you. Let me look up the other new case. Mr. McCaslin, you received a bond on the theft by receiving case. It doesn't say anything in here about whether you posted that bond. How long have you been in jail?
I've been in jail for almost 4 weeks now.
Okay, so you must have made bond on the theft by receiving case. Got it. It just doesn't show that you posted bond. So you got out and then were arrested in connection with this situation. Okay. The address that's listed for you in the system based on that theft case is 2751 Hamilton Road.
I haven't stayed there since 2012, I think. That's Cobb County.
Yeah, it is Cobb County. So that's an old address. This Old National is the more current address. Is that the hotel room or that's a house?
That's the hotel room.
Okay. All right. Okay, Ms. Clark.
Yes, Your Honor. The state is asking for this court to deny the bond in this case. First, Your Honor, based on the strength of the case in this matter, this is more than just a reckless situation, a child murder that could have actually been prevented. In this particular case, the defendant, the deceased child, Josiah, he actually was rushed to Choa Hospital July 19th of 2024 for poisoning of THC. So he tested positive for THC based on infirmities in his body. He was kept overnight. So the parents were under monitoring by DHS at that time because of that. Moving on to, in addition, Your Honor, the August 12th, the College Park Police Department, their special operations did an undercover buy. The defendant in this case is alleged to have sold drugs to a confidential informant out of that hotel room that the child was in this case. In addition, the date of the incident, Your Honor, there is surveillance footage that shows that provides where the hotel is And also you can see who goes in and out of the room. There's surveillance footage that shows that that Ms. Kuykendall left the hotel room, and defendant McCaslin was not in the hotel room. The child was in that room unattended for a great length of time, based on the timestamps. And there was a level of deception once the child actually came to Showa and was pronounced dead. The parents sort of kind of like their stories were differing. There was a search warrant completed. A enactment was done by Deputy McCauley in this case.
What was the word you used, or what was done by?
A reenactment, so that the parents could, I guess, give their account of what happened. And there was deception in that particular, what they were saying happened. But if you see the surveillance footage, you see that the McCaslin is seen running out of the motel room with the child in his arms. He's making a phone call. Defendant Kuykendall, she's seen going and throwing a white trash bag into a trash can near their room. Then McCaslin gets into an ambulance with the child around 5:12 p.m. And defendant Kuykendall actually left the hotel room in a vehicle. Unknown male actually is seen on camera getting that same trash bag out of the car, out of that trash can, and then getting in the car with defendant Kuykendall. An autopsy was done on the deceased child in this case. And it was determined, the toxicology report determined that at the time of death, that the deceased child had 10,541 milliliters of cocaine and 53.2 milliliters of methamphetamine in his system. It was determined that the child's cause of death is combined toxic effects of cocaine and methamphetamine, and the manner of death was concluded to be a homicide. And for those reasons, Your Honor, the state is of the opinion that based on the strength of the case, that the defendant is, first of all, a risk of flight because of the fact that he does have an FTA from 2018 out of Gwinnett County. And he does have a failure to report from a probation violation in 2018 as well. He has April 15, 2019, a probation violation out of Gwinnett County again. And he's a threat to community and people because based off of the evidence in this case, the defendant was actually selling drugs out of the hotel room that they were actually living in. We do believe that there is a risk of him committing felonies pending trial. The defendants in this case share another child, Legacy, who, even though the child is with a family member of hers, that child is being monitored by DHS based on the seriousness and circumstances of the case. And for these reasons, Your Honor, we're asking that bond be denied in this case.
Mr. Cazzoli, anything you want to add in closing on behalf of Mr. McCaslin?
Yes, Your Honor. So there was some of the information provided by the state, of course. This is a much more complete officer narrative and warrant that I have. So some of that, Your Honor, I was aware of. But I will say, Your Honor, the state described this right off the bat as something more than reckless, and then proceeded to describe facts that perfectly describe reckless behavior. And that's, again, just within the four corners. This isn't us necessarily agreeing to any of these accusations, but it does, the picture that's painted here is pretty much by definition one of recklessness. I will also note, Your Honor, and again, I do want to be careful before preliminary hearing, especially before Ms. Kuykendall has any sort of representation of her own. But I think it's important to note for the purposes of bond, Your Honor, that the description provided by the state, any time she described the conduct done by Mr. McCaslin, is that he wasn't at the home and Ms. Kuykendall was there, and then Ms. Kuykendall left. We'll also note, Your Honor, that Mr. McCaslin was again described with whatever else was going on there, as taking the child and running to a car on the phone, which is exactly the sort of response you would want from a parent. There was a potential overdose, a potential consumption of poison. So again, Your Honor, we understand that the accusations are serious, and none of this is a request to dismiss or downplay any of the accusations. But what was described by the state, Your Honor, I think it supports the idea that Mr. McCaslin is somebody who should get a reasonable bond in this matter as requested.
Okay, thank you. Mr. Cozzoli, I think you have a compelling case at this juncture that may get only more compelling about this being more about recklessness than evil intent. I hope that's how the case plays out, mostly for Mr. McCaslin and Ms. Kuykendall's soul, that this was a tragic, tragic accident. It's not a great case for bond because I find that while Mr. McCaslin was out on bond for a theft case, he was in a situation where either he had large quantities of personal use methamphetamine and cocaine, or was involved in that as a side hustle. Times were tough. They were living out of a hotel room. It wasn't a time where working as a maintenance worker was meeting all the many needs of the many children that Mr. McCaslin has. My concern is not flight. I don't think Mr. McCaslin would leave behind the family that he's got. My concern is that I don't think there's a set of conditions I could impose that would keep Mr. McCaslin out of trouble. Not the kind of trouble that is alleged here, but the kind of trouble that resulted in these allegations because of what was going on in and out of that hotel room. That said, I am happy to revisit this after a preliminary hearing where more evidence comes to light. And Mr. McCaslin, I told this to the previous defendant here, not Ms. Kuykendall, completely different case. You are entitled to a bond, absolutely, if the state has not indicted your case within 90 days. So we will reconvene at a minimum on day 91, if not day 90, if the state has not indicted you. And we could reconvene before then if Mr. Cozzoli, in looking through the information he gets through a preliminary hearing, thinks we ought to talk about this again. Ms. Clark, anything else from the state?
No, Your Honor.
All right, thank you.
Your Honor, may I be excused?
Yes, ma'am, appreciate you being here.
Thank you. You too. You gotta go back downstairs.
One left. It's the turn.
Oh, okay.
So, Mr. Abate, we reached out to Ms. Baker. I'm not familiar with that attorney, but she now represents position 10, Mr. Beatty. She had no notice to be here, and I don't think she's going to be able to make it. But that just may, when she plugs in, she may file a motion for people who need to hear it. She got a couple of days if it's going to be this week. Otherwise, thank you, sir, for being here on behalf of your son. Appreciate it. In the new year, we need to hear bond, if that's what she's pursuing.
Okay.
All right.
Yes, Judge.
So, Mr. Cozzoli, you've been doing an excellent job pivoting one to one to one. Are you ready to talk about Drinkard, or do you need a minute?
Your Honor, I should be ready to talk about this Drinkard.
Great. When you all are, they'll bring him out once they, okay.
Guess what I said, y'all shouldn't,
Pardon me?
Ted was.
She's here?
She's doing 2 weeks.
Did she? Dang. So that means she got out. I thought Ms. Tidwell, if I'm remembering the right person, I thought she was not competent. I thought that's where it got left. That we didn't even adjudicate it because she wasn't able to stay on point. Oh my gosh. Maybe she did something in jail. Okay, you would know better if you were working through that. Carolyn is her name, you think?
I remember her.
Yeah. We gotta wait for the court reporter to come back. We'll get started. All right. I think we've got our last bond hearing of the morning. It is 24 PI 008746. State versus, is it pronounced Drinkard?
Yes, sir.
Or Drinkard?
Mr. Call.
Drinkard. Mr. Drinkard is here, represented by Mr. Cazzoli. Mr. Abate is here for the state, and Mr. Drinkard, we're going to talk about bonds today. Your case is assigned to my division. As long as it remains unindicted, we talk about bond. At some point, the state may indict you. When they do, it'll be randomly assigned to one of 15 different judges. I'm one of them, so it may be that if you're indicted, the case stays here, but that would just be a coincidence. Chances are it'll end up in a different courtroom and it'll move forward that way. But until you're indicted, if there are any questions about bond, that's with me. And that's what we're going to talk about this morning. I'm going to hear from Mr. Cazzoli, and then I'll hear from Mr. Abate, and I'll let you know what we're going to do. Ready?
Ready. Thank you, Your Honor. Mr. Drinkard is 44 years old. Your Honor, Mr. Drinkard has been incarcerated. He was in prison for about 10 years before moving over here. So he's been in continuous custody. So he did not have an address when we first discussed. I've learned today.
Well, he got out at some point because this case is not from 11 years ago.
I'm sorry, it may be an approximate 10 years.
No, I'm fine that he was, I'm sorry for him that he was in for 10 years, but he must have gotten out of, no, this
case is from 2015, Your Honor.
Oh, this is a cold case. Okay, I just didn't see the date. When I was reading in the docket, the commitment paperwork, it talked about a drug deal and 2 people being shot. That just happened a long time ago.
Understood, Your Honor.
Got it. Okay, so after this incident allegedly occurred, Mr. Drinkard went to prison for what? Gun theft.
It was the gun theft. Okay, the federal charge. Yes,
okay, a federal case. Okay, got it. Okay.
Yes, Your Honor. My apologies.
No, my apologies. I was thinking, I saw the arrest date is listed as a few weeks ago, and so as I was reviewing these many cases last night, I guess I didn't pick up on the 2015.
Yes, sir. I think I buried the lead a little bit there, but
okay. But
yes, Your Honor, Mr. Drinkard, he has been in continuous custody for roughly 10 years. I believe it's probably 9 and some change.
Okay.
But he recently came across a new place to stay. He just let me know that today. I just need to call his partner, Your Honor, to get that address. I do not have that available at this time, but he will have a place to stay upon release, whenever that is. Your Honor, he's been living in Atlanta for the last 35 years. His whole family is from Atlanta. Again, the time in federal prison, I'm not exactly sure whether, I doubt that's within the city bounds, but he's been a resident of Atlanta for that time. Your Honor, he has a 10-year-old son as well who lives in Kentucky. He has his GED. He received that in the year 2000. And yes, Your Honor, I had it was the possession of a firearm and conspiracy charge plus probation. That was the foundation of that 2015 case that he served 9 to 10 years for. Your Honor, there's 2 different murder charges here, as well as the armed robbery and the drug charge as well. I think it is important to note, Your Honor, that this is a case from quite some time ago. The potential danger to victims or adjacents to the victims, such as family or friends, Your Honor, can have only decreased in this time. Your Honor, I will also, my understanding, Your Honor, is that his criminal history, aside from the most recent stuff, I'm not quite sure exactly what happened in Fulton County, so I can't really speak to his history beyond that.
I'll get it. We'll get it from Ms. Jackson in just a second.
Thank you, Your Honor. But we're gonna ask for a bond not to exceed 100,000. We're asking for 45, I'm sorry, Your Honor, 40 on each of the murder charges, 10 on the armed robbery and 10 on the drugs, so 90,000.
90, okay.
Oh, no, sorry, I did 10 and 10, 100 total.
100, okay, that's what you had said.
Yes.
Got it. Thank you for that. Ms. Jackson, can you share criminal history information on Mr. Drinkard?
Yes, Your Honor. He has 16 cycles. The last arrest was April the 28th, 2016. It was a federal case for a weapon offense. He does have prior felony convictions. One in 2017 is a federal case for conspiracy and theft of firearms. One in 2016 out of Douglas County for felony obstruction of an officer. One in 2014 out of Cobb County for theft by receiving stolen property and possession of a firearm by a convicted felon. One in 2010 out of Douglas County for theft by shoplifting. One in 1999 out of Cobb County for armed robbery and possession of a firearm. Nothing in addition, Your Honor.
Are you able to, I don't know, you have always much information, Ms. Jackson. Does that include how long a sentence was or just that there was a conviction?
Sometimes it lists the terms as well.
The 99 Cobb armed robbery, does it list any terms?
Just a moment, please, Your Honor.
Thank you.
10 years and 45 days.
Okay, you did the standard 10 years for the armed robbery.
Every day.
Okay, that's how it's supposed to work. Thank you.
It does say confinement 10 years. And it's, I guess they suspended 2 years. They say suspended sentence 2 years.
Okay, all right, thank you so much. Officer Evans, I saw you raise your hand. Did you want to add something?
No, Your Honor, that was the information I was providing.
Okay. Oh, I didn't realize that we've got Miss Simpson shadowing you. Hey, Miss Simpson.
Good afternoon, Your Honor.
Good afternoon. Yeah, it is just now afternoon. Thanks for bearing with us all day. Look forward to seeing you in court someday.
Oh, we will be there on Thursday, Your Honor.
All right, sounds good. Thank you.
Thank you.
Mr. Abate.
Thank you, Judge. The state would respectfully request you deny defense counsel's motion for bond at this time. I'd bring to the court's attention the defendant does have one prior failure to appear out of Cherokee County from March of 2010 for an entering auto. You've heard about the defendant's criminal history. What I would, I guess, highlight is he was convicted of the armed robbery in Cobb County in 1999, served the full 10 years, and then in 2010, less than 6 to 8 months after he was released, he was back in custody in Douglas County for theft by shoplifting and a felony, which he was convicted of. He then, in 2014, found himself back in the DOC custody for theft by receiving stolen property for a 2014 Cobb conviction. And then again in Douglas County in 2016, he served an additional year in DOC custody for what was reduced to felony obstruction. In that case, it was actually a charge for riot in a penal institution, and they reduced it down to of felony obstruction. And then in 2017, he began serving his time in federal custody for the conspiracy to either steal or sell a firearms situation, which he just currently, I believe, finished his time, which is the reason for the delay, because he was serving federal time. What I would say is it, for lack of better words, fell through the cracks in the sense that he obviously, as the court knows, that sentences for a federal sentence and a state sentence can't run concurrently, which was the thought as it relates to producing him here in Fulton County. As the court is aware, it's difficult at times to get federal inmates produced to a state facility while they're serving time. What I can say to the court is, as it relates to the evidence in the case, it's all evidence that's remained intact and preserved in the sense that it's video evidence, it's evidence from cell phone extractions where the defendant is communicating with the two intermediate parties as it relates to a drug deal. He's the actual drug dealer. It is a drug deal disguised as an armed robbery disguised as a drug deal that ends in the death of both Mr. Adams and Mr. Hilliard. Mr. Hilliard did survive shortly to where he was able to knock on a resident's door where this occurred in the area of Campbellton Road and Daniel Road, and was able to describe that he was meeting someone to purchase a large amount of drugs, and they robbed him and shot him. I will say the facts of the case are not something that's overly complicated or evidence in which has been spoiled or lost. But I would submit to the court, based on the defendant's history as it relates to committing felonies and felony convictions, that at this time the defendant is not an appropriate candidate for bond.
Did the case get stuck, may be the wrong word, but did it just not come across from Atlanta police, or they didn't ever execute a warrant, or they did and then it got stuck in major case? Why would we indict this? Because he's in federal custody, or where? Because he
second option.
The second option. Yes. It's been with the district attorney's office for a number of years. How does it hit your office's radar that now Mr. Drinkard is not in federal custody?
Surprisingly enough, his federal sentence was being tracked, and when they realized, or when it got to the point where the federal time was ending, was when I guess the district attorney's office made sure that the appropriate measures were taken in order to have him brought to Fulton County and the case to be indicted.
Understood. Okay. So Mr. Cazzoli, now that I'm better oriented to the timeline, so Mr. Drinkard did not get released to freedom from federal custody. When that sentence expired, he was transferred to Fulton County custody, where he has now been since the 26th of November, of trying to figure out what's going on with this situation.
Yes, Your Honor, and I think the state spoke to this a little bit, as did Ms. Jackson as well. I think even though the federal case didn't kick until 2017, he was initially picked up on the 2016 case, which I believe he was actually arrested for in 2015. So it really has just been continuous custody since about a month after these allegations.
Okay, and can you help me understand a little bit more what the federal case, since you pled to it, I don't know that you're exposing yourself to anything, but I want to understand what the allegations were. And your client can answer that if he wants to. You don't have to tell me. I'll learn someday. I'm just trying to understand. That's a lot of time for a stolen gun.
That's what they give out in federal statute. They go by your criminal history. It's guidelines.
I know how it works. I'm just curious what it was you think you pled to. Okay.
Conspiracy to, I had a tactical understanding with me and several people to break into gun stores and steal the gun.
Okay, so the ATF was interested in you.
ATF is who came and got me.
Yeah.
They spoke to me same time. Some of them came with these allegations. It distributed warrants and filed interstate agreement retaining acts, the whole bid. Paul Howard continuously wrote me and kept saying in writing, which should be documented somewhere.
Yeah.
At this time, we do not feel free to move forward with an indictment on this case. If we feel so to do so at a later time, we will contact you.
Okay. Well, it's good that you engaged in those exchanges, and insofar as you've kept it or it's in the record somewhere, your lawyer, probably not Mr. Cazzoli, but if and when you get indicted, is probably going to want to follow up on that to see if there were any timelines that needed to be complied with. All right, for now, I am not setting a bond. What I see is someone who has not had a super happy life from 99 onward, but it is in and out of custody for some pretty serious stuff. And we've got about as serious as you can get with an allegation of a double homicide. Those are only allegations, as opposed to your armed robbery. You either went to trial or you pled. That's a conviction. That happened. The federal stuff happened. So I appreciate these are only allegations. If for some reason the state is not able to move forward at the normal pace with this case, then Mr. Cazzoli, you should let me know and we'll revisit. I am not comfortable right now that Mr. Drinkard has sufficient ties to the community given his absence from the community for these many years. And I also, based on the criminal history, am not sure that I could impose a set of conditions that would guarantee Mr. Drinkard stay safe and the people with whom he's interacting stay safe. But I will revisit that if things change. And in particular, Mr. Drinkard, you should know that if the state does not indict you within 90 days, not of today, but when you first made landfall, then you're absolutely entitled to a bond. And Mr. Cazzoli is going to be keeping track of that. And he will be letting me know, Judge, we're at day 85 and there's no indictment yet. So put Mr. Drinkard on a calendar, which I will do. And unless the state slides an indictment in between that request and when we have a hearing, then we need to get down to business talking about numbers. Okay? All right. Thank you, everyone.
Thank you, Judge.
Thank you, Ms. Jackson and Officer Evans and Ms. Simpson. That gets us through the calendar. There was one name we didn't get to because there's a private attorney in the mix now, but that person's not going to be able to make it here today. So I appreciate everyone's time, and I will see some of you on Thursday morning.
Thank you. Have a great one.
You too.
Yes, thank you, Your Honor. Have a great day.
Thank you, Your Honor.
Thank you. Mr. Cazzoli, I appreciate very much your ability to bounce between 2B and here. I don't know if you have to hurry back there.
I do, Your Honor. I really appreciate the patience.